This evading was crazy. I mean, you could have killed people. You're still using drugs and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. My job is two things. It's one to more than that, really. One is to protect our community. Another is to punish, another is to rehabilitate. It's something where I have to potentially take chances that makes me sometimes uncomfortable. Your behavior is a danger to everybody here in Jefferson County. So she's on bond in a robbery. And I'm talking because I don't know what I'm going to do with you right now. Because I don't disagree with either attorney here today. Good morning, sir. Are you Desarian Adams? This is 23 DCCR 0492 and 0493.
TRP announcement.
On both cases, correct?
Yes,
What's the announcement?
Your Honor, they've made an offer, but we're going to need a hearing on this. We can't come to them.
Okay, so did we already go through the motion?
We did,
Did we start going through it and then stop? Because I didn't make any notations of pleads of true or not true. I don't think.
There didn't make any on this one either.
what we did was I was read through to all the violations except the new allegations, which were the misdemeanors. And you said, no, we gotta do them all. So we stopped. There's two misdemeanors there. I think one's a shooting.
Okay, I mean, and I wouldn't have said, I mean, I guess as far as an agreement goes,
We will go on work, but did not.
He did plead true to counts 3, 4, 5, 6, and 8. And it was reset for an update.
something happened and we stopped because I didn't make the notations and we didn't get it updated. So let's start back from scratch. We'll go through the motion, get pleads of true or not true, and then we'll reset it for a hearing. No, ma'am, I'll take care of it. Oh, there's two.
Yeah.
The second one, please. Okay, so Mr. Adams, best you can, raise your right hand, please. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You can put your hand down. And will your client waive the formal reading of the motion in each case?
Well.
So, Mr. Adams, in cause number 23, DCCR 0492, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation September 26th, 2023 for the third degree felony offense of deadly conduct, discharging a firearm. And that was a 5-year deferred probation. Is that correct? And then in cause number 23, DCCR 0493, I also have a motion to revoke your unadjudicated probation. This also shows you were placed on probation September 26th of 2023 for deadly conduct, and that was also a 5-year deferred probation. Is that correct? Both of these cases allege that you violated your probation. Count 1 in each case alleges that you committed the offense of fleeing a police officer December 6th of 2025. Is that true or not true? Count 2 in each case alleges that you committed the offense of unlawful carrying a weapon December 6th of 2025. And is that true or not true?
Not true.
Count 3 in each case alleges that you failed to avoid persons or places of disreputable or harmful character, and that on December 6th of 2025, the arresting officer stated that the vehicle operated by you and occupied by 2 passengers emitted the distinctive smell of burnt marijuana. Is that true or not true?
Not sure.
Count 4 alleges that you failed to immediately report your arrest to the probation department. Is that true or not true?
That's true.
Count 5 alleges that you failed to provide verification of performing the community service hours as ordered in each case. Is that true or not true?
Yes, not true.
Okay. Count 6 alleges that you were at a location other than your residence at approximately 11:23 p.m. December 6th of 2025. And is that true or not true?
True.
Count 7 in each case alleges that you were in possession of a firearm by having 3 pistols located on the back driver's side seat concealed under a black jacket in the vehicle that you were driving. Is that true or not true? And count 8 alleges that you're behind in your court assessed fees as of December 8th of 2025. in cause number 0493 in the amount of $540, and in cause number 0492 in the amount of $2,942. Is that true or not true? Okay. Did you enter your pleas of true in each case to counts 4, 6, and 8 freely and voluntarily? I'm sorry. And did you plead true to those counts because they're actually true? All right, then I'm going to find those counts true, find that you entered your pleas freely and voluntarily, find sufficient evidence in each case to revoke your probations and find you guilty. But I am going to reset this case for a hearing. Do you anticipate, I guess, a little bit of time on this one with witnesses?
I think so, Judge.
Like,
There's the offenses.
I'm sorry.
An hour.
Okay. All right. So we'll get it set for a hearing. I'll get an updated pre-sentence report and
We'll have some.
okay, we'll do it on a different day than a docket day then. All right, you can go back with the bailiff.
Did you were this?
Big excuse to that.
Yes, thank you. For the day. C is Mr. Cashin and Mr. Johns and Larry Fitzgerald Williams. Good morning. Good morning, you're Larry Fitzgerald Williams. And this is cause number 25 DCCR 0985 and 24 DCCR 1790. Mr. Williams is charged with capital murder as well as aggravated assault causing serious bodily injury. And what is the announcement, Mr. Cashin?
We need to take care of some housekeeping matters because the last time we were here, you had ordered the state to provide us with written notice whether they're going to seek the death penalty. And yesterday afternoon when I left my office, I had gotten nothing from the state as to whether or not they're going to seek the death penalty. And I would like that information as soon as possible in accordance with the order that you have.
Smith?
State's not seeking death penalty, Judge.
Okay, if you'll get that in writing to Mr. Cashin so he has it for his file. That way that gives him the opportunity to know how to move forward. I'd like to get this case, if it's going to be a trial, tried before the end of the year.
Yes.
And so I want to,
I agree.
And there are some other issues, Your Honor. Back when we first came to court, I had filed a motion to quash the indictment because the indictment, from what I understood, was incorrect because it was under a wrong provision and it was for retaliation against the judge. And they have not corrected that in that indictment.
just let me pull that.
Yes, ma'am.
So I think we discussed this, and it's only the heading, which is not substantive. Obviously, the substantive part of the indictment is what the actual charge is, which is the retaliation
Yes.
against Mr. Lewis. It's the indictment itself is not going to be quashed because of what's ultimately a typographical error in the top.
Okay.
I do think it's clean, or for the record, if you want to make an oral amendment, I think that's something we can do today.
Okay. Right from the state.
I think it needs to be correct as well. And it's not 18. I can't remember which one it is, but I'm gonna look. I know we had this conversation.
Yes, we have.
Do you remember which one it is?
In the very beginning, well, I left that file in my office.
That's all right. I can figure it out.
I mean, that is correct.
That is correct.
1900.
1903, 18 is correct.
It is.
I can live-
There was something that I do recall us having a conversation about, but
Well, it says murder for retaliation, judge, justice. I mean, that,
oh,
that
the
we can
judge
line
justice
through
needs
that.
to be interlineated, but the
Right,
section
that's-
number is actually
Okay,
correct.
that's
Yes.
what I'm,
That's okay.
that need to be done in there.
Any make an oral motion to
We would
do
make
that?
an oral motion to strike that from the.
Okay, and
Hold on. Any objection to that?
no, Your Honor.
All right, give me just a second to get it done before I move on. It doesn't want to give me that option yet. That's weird. And we need to, would you, make a note on a ticket? For some reason, the one thing that I need, which is the interlineation thing, is not letting me do it, and it has in the past. Okay. So I'm just gonna print it. Yes, and we'll do it that way. Okay, what else?
We recently got an email from Mr. Smith about some discovery, and I bought a 1 kilobyte, or I mean 1 terabyte drive to be copied, the information that he's referring to.
Okay,
And so I would like that. Then I have a motion to change venue right here, but I need to get Mr. Williams to sign his affidavit, and it will be filed this morning.
okay. So with regard to discovery, y'all can take care of that.
Yeah, yeah.
I don't need to get involved in that. And then, once, if something is filed, with regard to a change of venue, I'll get that set for a
Yes.
hearing within the next few weeks.
Yes.
Obviously, that's something we'll need to get taken care of so everybody can plan ahead
Yes, ma'am.
on what we're doing. So once it's filed, I'll
It'll be.
give everybody an opportunity to get ready and we'll get something set,
That'll
I
be
would
done.
say within 2 or 3 weeks.
Thank you, ma'am.
Okay, anything else?
That's it for now.
Okay. All right, if you can, if you need him, to sign that in front of,
Notary.
if you can step over here in front of the clerk, she'll take care of that.
Thank you. Thank you, Judge.
Thank y'all. She's gonna go get her,
Notary.
notice. Mr. Eckhart? Mr. Eckhart here? On, Bobby Clark?
Bobby Clark.
Good morning, you're Bobby Clark? And this is cause number 25, DCCR 0802. Mr. Clark is charged with indecency with a child by sexual contact. And what is the announcement?
Judge, this was set to this court date for a status. I think Ms. French had ordered the CPS.
Hold on a second. I need y'all to all hold it down, please. Go ahead.
Ms. French had, through the court obtained CPS records. We both have copies of those.
Okay, good.
So I think at this point, we're needing to just set this back on the trial.
Okay.
There's already a rejection on.
Has there been any change in what the offer was? It looks like it was back in August of last year. There was a rejection of a 12-year term.
Correct, Judge. And I don't know what Ms. French intends to do, but I do know that she is planning to meet with the complainant soon.
Okay.
And we talked about that today. If there is a change, we would obviously bring that to the court's attention
Sure.
beforehand.
Let's go ahead and get it on a
Yeah,
trial
yeah,
date.
just because of the nature of the case, I think.
Yeah, for sure. All right, so Mr. Clark, I'll get your case set on the trial docket. If something changes with any negotiation, y'all just let me know as soon as that changes and we'll get you back in here. Otherwise, we'll see you at the next on the first trial date, okay? Try and go back to the bailiff. Thank you. Oh, he's in trial. I wonder if, well, didn't he say anything about, oh, it's under against, Ryan's on our docket.
I saw that, no, he's finding out, they're having dockets.
Would you shoot him a message, to come take care of Spites real quick before, he gets going in trial?
We'll check on the way out, Judge.
Thank you very much. Appreciate you. Logan Eaglin, Ms. Perazzo.
Logan Eaglin.
Good morning. Good morning. Are you Logan Eaglin?
Yes, ma'am.
And I really need y'all to, if y'all are talking about a case, don't have to cross each other, get closer. I'm having a hard time this morning for some reason. Mr. Eaglin, this is 25 DCCR 0897. You're charged with aggravated assault with a deadly weapon. Your case is set for trial to begin with jury selection next Monday. And what is the announcement?
Judge, this is a case that the state will dismiss because we're re-indicting as a murder. We found out that the victim died approximately 7 or 8 days after the assault.
Okay.
So it would be not tried as the aggravated assault, but tried as a murder.
When do you anticipate that indictment?
I think it will go tomorrow.
Okay, so obviously if that's gonna happen, it doesn't change a lot of the discovery, I wouldn't think, and so we can go ahead and leave it on the trial docket.
Yes, ma'am.
because you've already got everything. It just changes the nature of the offense, correct? All right, so but I guess, I mean, if it's indicted tomorrow, it changes it enough to where if you need some time, you're entitled to that.
Yes, Your Honor, if we could have at least 30 days.
Yeah,
There will be at least an autopsy report and
so
pictures.
potentially
things,
some additional things for you to go over.
evidence.
Okay, so what I'm gonna do, Mr. Eaglin, is reset your case to the next trial docket, so that once Ms. Barrazo gets everything, any additional discovery, which it sounds like there's some more information coming because the case is going to be, upgraded to a murder charge instead of the ag assault. We'll give her some time to go over all that, go over all with you. If there's any new offers or plea negotiations, then let me know. If something changes before that trial date, we can get it taken care of.
Yes,
Okay, you can go back with the bailiff. Let's see, Mr. Smith, Mr. Wilkerson let us know that he is not going to be able to be here today, but that you already let him know. Are you ready on Dalvius Williams? Oh, okay. We're finished with Dalvius. Yes, ma'am. Williams. Thank you, sir. Mr. Radford, you have Floyd Torin, the sentencing. Good morning.
Why did you get the medical records and things else?
Who'd you send a medal to?
Kelly,
When?
maybe Revokes. No, I emailed them. Oh, it's 3 or 4 weeks ago.
Did you email them to Mr. Smith as well?
Did you get the medical records? Anything? Did you sound better? About 3 or 4 weeks ago. Yes, I think I did.
You're still using drugs and you haven't made, it's not like you're a young kid. You know what you need to do to get the help you need to get. And you've made a conscious decision not to do that. So at this time, in cause number 25 DCCR 0794, and this evading was crazy. I mean, you could have killed people. You got used, I think it was twice you almost struck intersection of Interstate 10 and 7th Street, almost struck another vehicle. And then again at 7th Street and Dollinger, you almost struck another vehicle. You crashed through a fence. Then you continued to flee after you crashed through a fence and crashed again and finally came to arrest. I mean, it's not like you just kind of sort of evaded. This is, I don't know, there was at least another email address. I know that it was home, so I wonder if it went to the wrong person.
No,
Correct.
what day was it?
It's about, huh? Spinal Pop stuff? Yeah.
What day?
Can you tell what day he emailed it?
No, I don't think I
This is
sent it
just-
the email. It
It was about 3 or 4 weeks ago.
Can you look and see what the date was?
From my office. If it's on
Oh,
hand, I don't know if it's gonna show on my phone.
All right, well, obviously I'm gonna need a minute to go through all this. He can go back for a few minutes or have a seat.
They can bring it back at office. Value.
This is discovery stuff. Some of this is. I don't think he wants to hand me all of this.
I gotta look at it. Somebody else should have to look at it.
I don't know what that didn't have anything to do with what I need to look at. I don't
So right there, should spin it.
Let's go ahead and get it back out. I'm fine. You can summarize for me as well. Nothing. I don't know. I mean, I guess it needs to be in the file. If it's something I've reviewed, it needs to be attached where the PSI is or something, please.
I mean, that's usually what I do. Submit additions to the PSI's email.
It was just with sounds like it wasn't like
It's all right. So you found it?
Yeah.
Okay.
Discovery.
That's quick. Yeah, with my discovery certification.
Okay, you're fully torn. And this is cause numbers 25 DCCR 0974 and 25 DCCR 1152. Mr. Torrin was previously in court, entered pleas of guilty to attempt to commit theft of property. It was enhanced to a second degree because of priors, and then evading arrest or detention with the vehicle, also enhanced to a second degree. I've received the pre-sentence report, and the agreement was for a cap of 20 years. It looks like it probably could have been habitual, but you guys pled it to just a straight second degree with an open plea to the second, correct?
Yes, yes, ma'am.
And I've received the pre-sentence report as well as some documents that Mr. Radford has sent in with regard to Mr. Torrens' mental health as well as some physical issues, and one letter as well of support. Have you both had an opportunity to review all of that?
Yes, ma'am.
Yes, Judge.
Are there any additions or corrections to that pre-sentence report?
I'll freeze it.
Just the things that I submitted, Judge.
Okay, Mr. Radford, you may proceed.
Judge, Mr. Toran has an extensive criminal history. However, as he has gotten older, he has had some health issues. He has vision problems. He has been seen and treated at Spindletop MHMR for some mental health issues. He has a very supportive family who is here today, and I'd ask that the court take that into consideration in determining his sentence.
What is the status of parole?
No, we're waiting on the other way. Okay.
Mr. Smith?
Judge, his extensive criminal history going all the way back to his juvenile years tends to show more about what he is and what he does than anything else. He's been given probation. He wasn't able to complete that. He has been sentenced to multiple long sentences in prison, and that seems to be the only thing that has kept him from committing new crimes in society, was the fact that he was incarcerated. I don't feel like probation is appropriate. We would ask for, we have given him consideration by coming off of the habitual and capped this at 20 years. So we would ask for a TDC sentence in the high range on this.
So, Mr. Torrin, in 2019, you received a 15-year sentence. So you were only not, I don't know how long it doesn't show me when you got out or how long you were in on that, but obviously. So you got out in 2023, and less than 2 years later, you've got 2 more felonies, which add up to your 11th and 12th felony offense. And I understand the issues with PCP. It looks to me like that's more of an issue than anything else. I understand there's some mental health issues, but you as a grown man have had every opportunity to get help and try to get in TDC, out of TDC, to live your life outside of prison, and you've chosen not to do that. I mean, your only time clean is when you're in custody. That's what you told the person doing that substance abuse assessment. I don't know. I just think it's I appreciate your family being here, and I appreciate the support, and I appreciate this letter, but it's all ridiculous when you look at your criminal history and the fact that you're on parole and you commit 2 more offenses, and your behavior is just a danger to everybody here in Jefferson County. So That being said, 25 DCCR 0794, I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of an attempt to commit theft of property, find that prior conviction true, or the prior convictions true in that case, sentence you to a term of 20 years in the institutional division of the Texas Department of Corrections. And cause number 25 DCCR 1152, find also sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Find that prior conviction true, sentence you in accordance with your agreement to a term of 20 years in the institutional division of the Texas Department of Correction. You will receive credit on each of these sentences for any time that you've been in custody that the law gives you the right to receive. I'm handing you, and they will run concurrently, which means together at the same time. I've handed you the trial court certification that shows these were agreements. I followed. You've waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. Read that. You should already understand it. But if you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Radford. All right, you can go back with the bailiff.
Maybe.
Yes, sir.
Some says.
So
Speak.
it's something. Is it in front of the judge?
Yes, well, he was unpacking his stuff, so that's means $3.
Yeah, those photos come first.
This is that he's been, if you'll make a note, that he was hired in August of last year, and this is the final reset. Make sure you let him know as well.
Thank you.
Ronald Spites, reset. Listen, Mr. Smith, that's the final reset on Spites for Mr. Gertz. So it's just in the third case, the new case.
And
Are there bonds in the motions?
she's on bond on the new case, the 22, who made 22,000. She's in custody, she's waiting custody on the TRP. We've said that it falls in the TRP, she's not bonded out. Okay. That the bond on the TRP is different.
What I said on that?
Uh,
I'm sorry.
25, 50, 25, 25.
Did I know that there was a robbery at
Yeah,
that time?
we were,
Yes,
we were
Judge.
just here.
You had actually indicated to me
Oh, that the robbery
that the
was
bond
low.
was low. robbery
Yes.
At 22.
20, yes, $22,000 on a robbery when you're on probation for 3 felony offenses seemed very low to me. And this is one of those things when we're trying to get it worked out where some of the magistrates, not some of them, depending on the case, they're unable to see if someone's on probation.
Mhm.
And we're trying to get that worked out because I think surely that was what happened on this one, because I know they wouldn't have done that. So,
I don't mind resetting the week.
yeah,
Uh,
let's do that, Ms. Holmes, so that you have an opportunity to look at the motion, as far as that, the robbery, which is 25-1826, the motion to increase the bond in that one. We'll reset it 1 week and we'll come back next week on that motion.
Okay.
And then we can, figure out where we are with regard to an announcement as well, potentially.
Okay, has bonds been paid or?
She's on bond in the robbery,
Okay,
but she's not on bond in the motions. I set bond
Okay.
amounts because they were deferred,
Right.
but she has not made those bonds.
Okay.
So we will only be here on an increase request
The
on
robbery.
the robbery.
Okay,
Okay? So we'll just reset it 1 week.
okay.
Mr. Parker, you've got Carrie Alt's 3 cases. So we've got 1 new case and 2 motions.
One judge.
Good morning. Would y'all mind putting the 2 motions? I'll do a new case.
I have 'em.
Carrie Alt.
I don't.
That's okay. Keep them for your file. Good morning. Are you Carrie Alt? And will your client waive the formal reading of the indictment and the motions in each case?
Oh, yeah.
Ms. Alt, in cause number 26 DCCR 0361. Oh, hold on. Wrong number. Should we get 26 DCCR 0319. Getting there. You're charged with the 2nd-degree felony offensive robbery from January 13th of 2026. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the tablet in that case some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Parker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Your Honor, just for the record, just so for the court's information, this offer in this case reflects the fact that the robbery, as it's charged, involved an assault of a loss prevention officer at HEB on the
1 hearing, 3 very different futures. A 20-year prison sentence, a deferred probation second chance, and a defendant fighting to avoid losing everything. Today's courtroom proved that every decision matters, and every violation carries consequences. Subscribe for more real courtroom breakdowns, and we'll see you in the next case.